Now, let me move on to the initial slide here. Let me camp out for a minute on school choice. And why is that? Because we're taking a very broad, comprehensive look at school choice. And as you can see on this slide, we've broken school choice into 6 different categories. Traditional public schools, which we'll talk about in a minute, charter schools, magnet public schools, online or virtual learning, private schools, and home education or homeschooling. And we'll talk a little bit more about how each of these different options for parents and guardians fit into the whole dynamics. So first of all, I wanted to talk to you about general school choice or regular school choice. First thing I want to show you, and I don't think that this is not going to apply to many of your districts, but essentially the law with Public School Choice Act is that there's a way a district can claim an exemption from participation if they have a court order that on a desegregation issue that they have to follow that requires that in order to meet that order that they do not participate in school choice. If that's the case, that district has to contact DESE, the Division of Education, Elementary and Secondary Education, and get a approval from DESE, get permission to claim that exemption. And you see on this slide a group of the districts that have done that. I want to camp out a little bit more here and talk about school choice in general. The window for school choice applications runs from January 1st to May 1st of each year. If a parent or guardian wants to participate in school choice to have their child go to a non-resident district, then they have to file the form with both the resident district where they live and the non-resident district where they want to go. And the non-resident district has 15 days to make a decision as to accept or reject. And their decision, once it's reduced to writing, is final. Okay? So now there are 2 ways that a school district can possibly not accept a school choice transfer. I say 2 ways. One of the big legislative changes in this area was the removal of the 3% cap. And you're probably all familiar with that. It basically said that a school district, the number of students it loses to school choice, it capped at no more than 3% of the district student population. Now that also really meant net transfers, so you had to subtract out from that. It's not just the number of students you lost to school choice, but the number of students you lost minus any that you gained through school choice. So there's one other way besides what we have on the slide for you to not accept a student under school choice. And that is, there's a part of the school choice law that says you can develop a policy, and I'm sure that all of you have done this, that says if granting a school choice request would cause you to go over 90% capacity in any grade level or classroom or program or building, then you would have the ability to deny that request. I think the main upshot of 790 is in that last piece, essentially there, that if you are if you're the child of a military service member or surviving spouse member or certain reserve components or veterans, then you're going to be able to enroll in any school district you wish, regardless of where your permanent residence is, and not have to go through the school choice process. Act 748, I want to talk about just a little bit. There's more to unpack than what's on the slide. For some sports, not all and not the majority of them, I'll use soccer as the example because this is what we heard about when we were at the legislature this past spring, going and observing the House and Senate Education Committees. Apparently with soccer that there is a problem, because if a student virtually, especially an upper class student, say a senior, who was looking at going to college on a soccer scholarship, this Arkansas Activities Rule, which doesn't allow you to participate in a varsity sport and then like a travel version or showcase version of the same sport, or you lose your eligibility for the varsity sport, was forcing those soccer players to choose. And if they chose to play for their school team, then they wouldn't be able to participate in these showcases, which ran basically the same length of time or during the soccer season for the school. And they were missing out on these opportunities. And so that was one of the things behind 748, is to correct that situation. 669, I will basically leave to your reading. 347, you are all probably familiar with what are called Act 1240 waivers. That is, if an open enrollment public charter school, which means a charter school not affiliated with the district, not a conversion charter school, if they have waivers, then a district has the opportunity to ask for one or more of those same waivers by filing paperwork with the department and having a hearing in front of DESE. And now the criteria for that is the same when an open enrollment charter tries to seek a waiver. Act 543, I will leave that to your reading. We have a situation where that would have impacted the Marbley Lane School District, for example, is a real life example of that. 630, essentially what's going on here, as you may know, is that before, if you had a homeschool student resided within your district and wanted to be able to participate in extracurricular activities, then there was a process that had to be gone through, and they could only do it with an adjoining district. Now that's a little bit different. If you've got such a student and the student wants to participate in a particular activity and you don't offer it, and there's a superintendent of any other school district that will agree to take the student, a homeschooled student, so he or she can participate in that activity and possibly attend a class or two, then that's allowable. All right, 633, you've probably kept pace with situations over the years where some school districts have been taken over by the state. You've probably heard of intensive support or level 5. They're taken over, and what this act does is clarify that the maximum amount of time that a school district can be under state authority is 5 years, and if they've democratically elected a board of directors during a special annual election, that return to local control must happen. Here's the slide, and I think either Jim or Ken have the same slide too. The Educational Freedom Account Act, which we're going to talk about in a little bit, there's been $52,100,000 appropriated for that. Act 129 was passed early in the session before before the act got passed, that eliminated the 3% cap. But this provided that a student who's eligible to transfer to a non-resident district would not count against the cap of the resident or non-resident district if the student attended preschool in the non-resident district at least 1 year before attempting to enroll in kindergarten. Act 649, we'll talk about this in a little bit, but just kind of a preview. These are groups of folks who are eligible starting this school year, 23-24 school year, to participate in the Arkansas Children's Educational Freedom Account Program. 768, what this act does is, well, I'll leave the language on the slide to your reading, but apparently there are situations that we're getting back to legislators of students who had indicated they were going to transfer to another district, and they were being denied participation in extracurriculars or disciplined exclusively because they've decided to transfer schools. And the legislature acted on those concerns and adopted Act 768. There's some of the language there. Act 850, I'll leave to your reading. Act 731. Now, probably some of you, perhaps even most of you, before this school year participated in what I'll call either some districts call them board-to-board transfers, some call them legal transfers. That is another school way for parents to school choice in your district. Is, let's say they want to go to your district, so they would have to go through a process where they petition their resident district's board to be released from that district, and then file paperwork with you at your district to see if you as board members for the non-resident district will accept their school transfer petition. I think what was going on here, and up till now there had been no requirement that a district participate in board-to-board or legal transfers. And that has changed with Act 731, because apparently it was getting to the attention of legislators that a family would file a transfer petition with the district and would never hear anything back on it. It would just sit, and the district didn't act on it. And the district didn't have to, but it never got in touch with the family to say, hey, we don't consider legal transfers. Now, the legal transfer has to be considered, as you see on the slide. It has to be placed on the next regular monthly board meeting of the school district board of directors. Now, two things to keep in mind. The passage of this act does not mean that a board has to approve every transfer. It does say that you can adopt a policy to have the superintendent have the ability to approve if the district's going to legal transfers by himself or herself. However, if the petition is going to be denied, then that can only be done by the board. That can't be delegated to the superintendent. Okay, course choice program. I want to talk about this a little bit. You should already have a policy in place for this. It's effective now, even though DESE has up until the 25-26 school year, if necessary, to roll that out. So your policy on course choice should indicate that if you have a student within your district that's attending this public school that does not offer the course they want to take, as you see on the slide, or is attending a school that received a letter grade, their most recent letter grade was C, D, or F, then they have the ability during the time that's set aside at your district for students to choose their courses to look at this catalog and see if other education providers or school districts or schools offer the course that they want to take. That is something that would be compensated for, be paid for out of your funds. The Act provides that there will be some that remains with the district. I believe it's 10% of the funding on that stays with the district. It's important to remember that if a student avails himself of this, that means that they're still going to be required to take any required assessments with you. Include statewide assessments, advanced placement, and international baccalaureate if you have that. Can still participate in extracurricular activities and still be entitled, if they're special ed students, to receive all the services that are required under their IEP. Any credits that they get are going to appear on their official transcript. They're going to also fully count towards the students' graduation requirements. There's a provision in there that also talks about not the resident district not being able to really discourage the student from doing that. Educational Freedom Account Program. So essentially what that means, if a student qualifies for this program, then they will get a certain amount of money, and it's I believe 90% of last year's per pupil student funding, which I think comes to about $6,700, placed into account. And that money will be placed in the account. There'll be a total of 4 payments that will make up that amount, and DESE is responsible for putting that amount in there. And what that means is that for students who qualify, they can use those funds to pay for what's called qualifying educational expenses, tuition fees, etc., from participating providers, which includes private schools. Now note that that doesn't mean that whatever the students say they go to a private school, that doesn't mean that whatever that private school charges, that those funds will pay for. Again, they get a certain amount that can be put towards that. If there's any additional that has to be paid, then the family is responsible for paying that. You're probably familiar with the Succeed Scholarship. A part of the eligibility is those students who were formerly in the Succeed Scholarship program, which no longer exists, are part of the group that's eligible this year. You see here the list of individuals that are students that are eligible this year to participate in the program. There's a cap on the number of students who can participate, and that will grow as we go through the next school year, this school year, and the next school year. In 25-26, there'll be no limit on that. That concludes my portion of the presentation, and now Mike Helms is going to join you for the safety piece.